Any mention?
No mention. Come. Sorry.
Any mention?
Your Lordship, I beg to move a mention memo for listing of 2 matters tomorrow, Your Lordship.
Why?
Your Lordship, the petitioner is the CEO of Joai Urban Cooperative Bank, and his service is being terminated at the expiry of...
It's a private case, not
Yes, Your
a government matter.
No, private matter. Obliged, Your Lordship.
Yes.
Your Lordship, I beg to mention a memo number WPC number 99 of 2024, Your Lordship. This matter was listed on Friday and it will be listed on 22nd of this month, Your Lordship, but due to some personal difficulty of the conducting counsel, so Your Lordship kindly list on the 24th of this month, Your Lordship.
Why mention it now till 27th?
But Your Lordship, I just got informed that kindly list on the 24th of this April.
It's a long way away, yes.
Much obliged, Your Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item number 19 and 20, Your Lordship, which is a connected matter. I pray if this matter may be listed after 2 weeks, Your Lordship, as the learned DSGI is on leave, Your Lordship.
19, 20.
Yes, Lordship.
Where's
connected matter, Your Lordship.
Okay. Yes,
For
because
item
yes.
number 19.
Yes. Right after
2 weeks, Your Lordship.
2 weeks. Yes. Yes.
Similar prayer for item number 38, Your Lordship.
38.
Yes, Your Lordship.
38.
Yes, Your Lordship.
Yes, 38. 2 weeks. Yes. Obvious. 38. Yes. Anyone else?
Highly obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item 20, Your Lordship.
Item?
20, Your Lordship. 20.
Why speak such a low voice? 20. 20 has already
Yes,
been
yes.
mentioned. You didn't hear just now.
Your Lordship. Lordship, item 31, Your Lordship. 31.
31.
Yes, Your Lordship.
Speak loudly, yes. Who's the other side?
No objections, Your Lordship. Item 30 also connected, Your Lordship.
Permit AC. Yes, okay. 1 week, yes.
Highly obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 21, Your Lordship.
21.
Yes, Your Lordship. I humbly pray let this matter be taken up next week, Your Lordship. Let this matter be taken up next week, Your Lordship.
One?
Let this matter be taken up next week, Your Lordship.
We'll dismiss it now.
No, Your Lordship,
After 1
because
week,
we
yes.
just
After 1 week for dismissal.
No, I don't know, Your Lordship.
You don't know?
No,
Okay.
Lordship.
1 week, yes.
Yes. Similar prayer for item number 35. Let this matter be taken after 2 weeks. Your
25?
Lordship. 35. After 2 weeks, Your Lordship.
No objection, Your Lordship.
2 weeks. Yes, okay.
Obliged, Your Lordship.
Your Lordship, I beg to mention item 28, Your Lordship. Item 28, Your Lordship. Your Lordship, I humbly prayed for 2 weeks' time, Your Lordship.
Where's your side? Other side who's there? This matter is supposed to finally heard today, actually.
Your Lordship, we already informed the petitioner, Your Lordship.
Doesn't matter, you're not the petitioner. Or if you're from respondent.
Yes,
Who's for the petitioner? There's no one behind the petitioner. Where's that?
petitioner M. Yao Sai, Your Lordship.
Yes, she was insisting that this matter, because matter's in the final stage. You appear who's Mr. Hazarika?
No, Your Lordship, for respondent number 5, Your Lordship.
The school.
Yes, Your Lordship.
1 week, okay. Otherwise, this matter, we won't, not going to adjourn it. You were there, Mr. Abraham, we're keeping quiet also.
Actually, this matter has been conducted by this Karwalang.
By whom?
By this, actually, KP. Sorry, Your Honor.
Your government has to have a big overhaul. A lot of other good lawyers around, yes. Yes.
Also, Your Lordship, I beg to mention item number 32, Your Lordship.
32.
I humbly prayed for 2 weeks' time, Your
Where's the
Lordship.
petitioner?
No objection, Your Lordship.
At least if there's someone, if it's mentioning it's for a petitioner, someone should be there. Yes. You can't take a grant. Suppose the court doesn't adjourn. 1 week, okay. Yes. That's it. Yes, call out the matter.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 29. I pray that the matter may come up
And for
after that.
I'm no objection. 1 week, it's okay.
Leave like.
May I please, Your Lordship? I beg to mention item number 34, Your Lordship.
30?
34, Your Lordship.
Why?
Personal difficulty of the conducting counsel, Your Lordship.
Who has responded? Mr. Kanta?
They were supposed to file affidavit, Your Lordship.
No, we'll close the contempt. Just after 1 week, it's made clear that if this matter is taken up, matters done. We'll close it. We'll close the matter otherwise. You can't carry on this way. But after 1 week, yes. Yes.
Daily list item number 1.
May I please, my lord? My lord, this case pertain to pension.
To pension?
Yes. The petitioner before your lordship is a driver in the office of respondent number 3. He joined his service in the year 1995, and thereafter, my lord, after serving for 28 years in the service, he retired in the month of December 2023.
When did he retire?
December 2023.
What is the reason why they're dealing a pension? 23?
Yes.
All the service books, all right?
Yes, all the service book is all right. The only reasons, to the best of knowledge of the petitioner, that the pension paper of the petitioner whom she is supposed to process by the department concerned has not been done.
You take notice, but Mr. S.M. Suna issue notice. Mr. Adgurung Ji is present. If you have all the respondents, go for a call for let's for 3 weeks for affidavit for instructions. Yes.
Item number 2.
Item 18 comes call for.
My lord, in this case, the petitioner before your lordship agreed for the non-payment of the compensation to the petitioner and the member of the association of the petitioners for the damage or destructions of the water supply and pipeline of the petitioner by the respondent number 1. The NHI
compensation
for destruction of the pipelines and then water tanks and the supply line of the.
Has it been assessed the damage?
Yes, it has been assessed, and then the report has been submitted.
Where's that report?
Page 47, my lord.
Who has done the?
The respondent number. No, he is the Water Resource Department.
Oh, widening of Shillong Dauki National Highway.
Yes, my lord.
So we are claiming compensation from whom? From the state?
The implementing agency, respondent number 1.
Were they party to this?
Yes.
Who is appearing for the?
I'm for the respondent 1 and 2.
Yes. You take this, get instructions. I've not been paid any amount at all.
No, not at all, my lord. Despite of representations and.
Paid for 3 to 11 minutes, and the prayer is directed against 1 and 2.
1 and 2.
Anything to say right now?
Respondent 1 and 2 is not responsible for making payment direct to the petitioners, because it will go through the deputy commissioner.
No, but you have to get the money ready. Whoever implementing agency, whoever pays it, is just a disbursing agency. But Mr. S.M. Suna issue notice returnable in 3 weeks. Mr. R. Devnath is present ex CGC accept notice on behalf of response 1 and 2. Mr. S. and Mr. S.N. G is present except on behalf of 3 to 11. They start with 3 weeks for instruction to activate. Yes.
Obliged, one.
Item number 3.
Yes, Mr. Siddiqui.
This is for non-payment of gratuity and medical reimbursement to the municipal employees since 2012.
But that's not, this matter has not been, it's the same matter that you brought again. It came for this court before.
That was some another matter, my lord. It is for payment.
It's not the same matter. Same?
No, not the same matter. No, it is not the same. Earlier it was for salary, my lord. Now it is for gratuity and medical reimbursement. Medical reimbursement was never agitated before, your lordship.
Page 56, my lord, page 56 of the petition is the order passed before in this case. In
that was whether gratuity will be payable under what law, that was the trigger. But here we are saying that payment has not been made to us.
Now, you are appearing for the municipality. Have you started? They have this order. This was passed in 8th of December 2020. It says that in such circumstances, we dispose of both repetitions or direction the chief executive officer shall to take a decision in the matter of regard to payment of gratuities, employees being represented by so and so under the Payment Gratuity Act 1972. What has been done after that?
That order was passed by the municipality that Gratuity Act will be applicable. Yes.
We are paying gratuity, Your Lordship.
You're paying that?
Yes, Your Lordship.
And what
No, my Lord, only order was passed.
Yes.
Only the order was passed, but gratuity was not paid since 2012 onward, my Lord. That is my...
As per my instructions, Your Lordship, we are paying gratuity, Your Lordship.
No, but their own, my Lord, papers which they have submitted in the court.
Learned senior counsel assisted by so and so for the petitioner issue notice. You're there for
the state. That's my number one.
SI is there for number 1, and Mr. Pasante accept notice we have for number 2. No further notice required. Just after 3 weeks for instructions or affidavit.
God bless you.
Yes.
Item number 4.
Please, Your Lordship.
There's offers noting here, Mr. Sen.
Hello.
That says that certain pages you have annexed some documents which are in foreign language.
Look, that was the issue because I was going through the High Court rules. These are in foreign languages. Now, we can't certify the foreign languages, my lords. That's the only reason why. These are just vouchers. I assure my lords that that does not have a very serious bearing on this issue.
You can't use Google Translate.
Lords, I don't think I can certify it. We will do that, my lords. We can file an additional affidavit and use the translation.
Now, what does the voucher say? What does he say?
There are payment receipts, my lord, issued by foreign companies.
Then how do you understand it when you're preparing the brief then?
We did not refer to that specifically. There are other orders which are of relevance in this case, my lords.
Yes.
Well, the facts are, my lords, that the petitioner is engaged in the business of manufacturing Indian-made foreign liquor, and it had entered into an agreement with certain companies from Netherlands for the purpose of using their brand name. So they were authorized to use their brand name and manufacture those products and sell it in India. So pursuant to this understanding, they applied to the Excise Department in Shillong for registration of the brand label. This was rejected by the Excise Commissioner on the ground that the private respondent number 4 already had that brand registered in its own name.
Who's number 4?
Well, it's Tilak Nagar Industries. The array of parties is at page 3.
Who are you?
I am the petitioner, Willets.
Yeah, where is your distillery?
My distillery is, we have to enter into a bottling agreement with somebody in Meghalaya.
Okay.
So against the rejection order, which was passed without giving us an opportunity of hearing, we approached this Honourable Court by way of a writ petition. While setting aside the rejection order, this Honourable Court directed the Excise Commissioner to reappreciate the matter, pass fresh orders in accordance with law after giving us
but why
an
are
opportunity.
Copyright issues?
My lord?
Are they copyright or issues?
No, not copyright issues.
To the brand.
No. Yes, correct. There is a suit pending before the Honourable Bombay High Court.
Yeah.
And there is a counterclaim also pending before the Honourable Bombay High Court. So these facts were brought to the...
Between you and?
Tilak Nagar. My lords, between the original company based in Netherlands, they have filed the suit before the Honourable Bombay High Court. So there is a counterclaim which has been filed by Tilak Nagar Industries. That is also pending. Now in
so
that
the thing
certain...
is that you have taken your license from this
company in Netherlands,
company.
Lordship. There was a deed of assignment. On the basis of that, I'm authorized. We've enclosed it, my lords. So on the basis of that, we've been authorized to use that brand name. Now, these facts...
dispute, what about the other Tilak Nagar using the same brand also?
Yes, my lords.
Then how...
They were... What has happened? Prior to 2014, by the same brand label, they had launched a product in Meghalaya. But in view of the pending suit before the Bombay High Court, their brand renewal has not been renewed as yet. My lords may recall there was a product by the name of Mansion House French Brandy, which was being sold in Meghalaya. Now that is discontinued because their label has not been renewed any further.
Okay, no, just court wants to know just for. Now this Tilak Nagar Industries is selling the same liquor.
No, they are not selling the same liquor, my lords.
Then what are they claiming then?
So they claim that there has been a copyright infringement, that they are the owners of this particular brand.
Owners of that copyright.
Lordship, because there was some sort of an agreement between them and the Danish company, but that dates back to 1980s. That was a conditional grant. We claim that there was no assignment or transfer of any of the rights.
You stake your claim from the Dutch company.
Correct, my lords.
Where's the deed of assignment?
Well, there's a deed of assignment. Is at page 70. 21st of August 2014.
Allied blenders.
Lordship. So, my lords will see the original Dutch company is named Herman Janssen Beverages, Netherlands.
Yes.
And Uto Asia Private Limited. And the assignment was made in favor of the petitioner, Allied Blenders and Distillers Private Limited.
Are you selling other parts of India?
Not yet, my lords.
Then?
So we have very recently, as 23, applied to the excise department in West Bengal, and they have allowed us to register the brand name. Now, I'm just coming to the dispute, my lords. So we had approached this Honourable Court against the rejection of our request for registering the brand label. This was in around 2014. So we approached this Honourable Court. This Honourable Court set aside the rejection order and remanded the matter back to the Excise Commissioner with the direction that they reappreciate the matter and pass an order in accordance with law. So the parties appeared before the Excise Commissioner and placed their respective cases. One of the issues was the factum of the suit that was filed by the Danish companies, as well as the counterclaim which was filed by Tilak Nagar before the Honourable Bombay High Court. Now, there was an order passed by the Bombay High Court in relation to some interlocutory application which was filed by Tilak Nagar. In that, their prayer was not granted. However, there was an observation made that we could go ahead and launch our products, except that we would have to take leave from the Honourable Bombay High Court.
So you could go ahead and launch your product?
Yes, we could introduce it in the market. That is the language. Yes. Except we would have to take leave of the Honourable Bombay High Court.
Leave.
We have already filed that. In our humble submission, registering the brand name before the excise department and actually launching the product, these are two different components.
But even then, once you register, that means amounts to, a green signal.
That would be the precursor, in my humble submission.
It's just that it's done. I mean, half the work is done. Or more than that. So once you register, you mean to recognize that it is a valid brand name to be, for launch in Meghalaya. But once you launch your product, it's here, I've already registered, it'll come another writ. Now, after registering, how can with one hand give something and with the other hand take it away?
Lordship, that is our understanding, my lords, that
where's the order of the Bombay High Court?
Lords, kindly have page 306.
Long order.
Lordship. Page 306 is the order dated 10th of September 2014. This is in the counterclaim and in an interlocutory application which was filed by Tilak Nagar.
What's happened to the case? Still pending?
It's still pending, my lords. In fact, this application is also pending. It has not been heard as yet. Not been disposed of. My lord. Kindly see the operative part is at page 310.
Yes.
Para 8 onwards. I believe the interests of justice are well met by the following order. The defendants to the counterclaim shall file their affidavit in response to the further affidavit on or before 19 September 2014. Affidavit and rejoinder, if any, to be filed and served on or before 25th September 2014. Notice of motion to be listed on 30th September 2014 on the supplementary board for hearing and final disposal. If the defendants to the counterclaim, that is the original Danish companies, proceed with the obtaining of licenses or other permissions in the time, they will do so at their risk and peril and subject to the result of this notice of motion. Now, this is relevant, my lords. Till 30th September 2014, the defendants to the counterclaim shall not introduce any products with the subject trademarks into the market without leave of the court. So it talks about introducing it in the market for actual sale. Now, kindly see page 312. This arrangement was further extended. Can you see the last line?
Yes.
Ad interim order passed earlier in the matter to continue pending disposal of the notice of motion. So this was the last order. Now, all of this was placed before the Excise Commissioner, but perhaps the Excise Commissioner did not appreciate this order and rejected our application yet again. But the reasons assigned was the pendency of the suit before the Honorable Bombay High Court, and yet the matter was yet to be adjudicated.
Even then, unless there's some tangible, what do you call it, materials in your favor.
Lordship.
Otherwise, now this is in the air. This matter is pending on a notice of motion stage.
Correct.
Bombay High Court.
No, also, Manoj, the observations are in our favor. It does not restrain us. I'll just come to this, Manoj. What's happened thereafter?
Do you think the Commercial Excise at the level can appreciate these, this finer,
they're not required to. They cannot go into title, Manoj.
Points of the orders.
No, correct, Manoj.
Court maybe can, but then.
No, they cannot go into that. All they have to look at prima facie is whether I have a trademark in my favor. That's all.
You don't.
No, Manoj, I have a trademark in my favor. That has been recorded by the Calcutta High Court as well. I'll just finish up the facts very quickly.
Calcutta High Court also?
Yes, Manoj. I'll just come to that.
Okay.
So what's happened against the rejection order, we preferred a statutory appeal before the Board of Revenue. Now, while this matter was pending before the Board of Revenue, there were some interesting developments. We approached the Excise Department in West Bengal on the same set of facts and applied for approval of the same brand name. This was allowed by the Excise Commissioner, despite the strenuous objections raised by Tilaknagar Industries. Thereafter, Tilaknagar preferred a statutory appeal. That was disallowed. And they, in fact, appreciated the orders passed by the Honorable Bombay High Court and made a distinction that order did not restrain us from seeking registration of the brand label. Thereafter, Tilaknagar approached the Honorable High Court.
Now, whether registered or not, doesn't mean that if the Commercial Excise in Calcutta has registered your brand, that they are bound by that.
No, I completely. I'll just take your lordships to that reasoning for a moment. So, there against the Tilaknagar approached the Honorable Calcutta High Court. The Honorable Calcutta High Court passed a detailed order. Well, let's just come to that for a moment, Manoj. So the order of the Honorable Calcutta High Court is at page 934.
934.
934. If lordships have it. 934.
Yes, 934, right.
934. This is an order dated 17/8/2023.
Yes.
And the relevant part of the order is at page 945.
Yes.
Page 47 onwards, my lord.
Para 47.
Para 47, I apologize.
Yes.
Para 47 onwards. The finding of the single judge of the Bombay High Court dated December 22, 2011 as to U2 having ceded rights to the petitioner were merely a tentative finding returned in connection with a motion at the interlocutory stage against which an appeal is pending. In fact, the main suit itself is pending and the subsequent order of the learned single judge dated 10 September 2014 was passed with full knowledge of the previous observations dated 22nd December 2011, holding that UTO has assigned the trademark to the petitioner. Hence, it is the last order which prevails, by which permission was granted to the respondent number 6 to obtain licenses and or other permissions at its risk and peril. Thus, I find no irregularity or illegality in the orders impugned herein.
I mean, even now you come here at your own risk and peril only.
No, I completely understand. Well, as far as the Bombay High Court's order is concerned, like I said,
right,
the only distinction being made here, as far as we are concerned, is the launching of the actual products and the registration, which is actually a precursor. Those are initial requirements, peripheral requirements that are required to be obtained. So kindly see this order. I find no irregularity or illegality in the orders impugned herein passed by the Excise Commissioner or Additional Chief Secretary granting registration to the respondent number 6 in respect of the brand name, which is disputed here. Subject, however, to the restriction in terms of the order of the Honorable Bombay High Court dated 10th September 2014.
It's on a different footing because in that case, the Commissioner of Excise already registered the brand.
Yes.
So he didn't interfere because that's the discretionary power. They have said, okay, fine. They deem it fit that they should be registered.
Lordship.
But out here you're trying to get a direction to issue mandamus to them to register the brand.
Or else certiorari, my lords. Why I point out, because this was placed before the Board of Revenue for its consideration. Now, the Board of Revenue, I agree, they could have at least passed an order disagreeing with this reasoning. Right. But the order is completely bereft of any reasoning whatsoever, my lords. It's been passed in a very mechanical order. Kindly see the order. This is at page 32.
From 945 to 32.
Well, this was the impugned order which we had enclosed right at the start, my lord.
Oh, okay. 32. Yes.
This is an order dated 20th of December 2023.
Yeah, okay.
So I'll just take Lordships to the relevant part. It's at page 34.
Yes.
Well, may I read? Parties have filed their written arguments, heard the counsels for the appellants and the respondents in detail, seen and perused their appeal written statement filed by the parties, document available on record, written arguments of the parties, as well as the finding and order dated 11 July 2016 passed by the Commissioner of Excise, Meghalaya, Shillong. On examination of record and hearing of the counsel so-and-so and counsel so-and-so, we are of the view that finding an order dated 11/7/2016 by the Commissioner of Excise, Meghalaya, Shillong is
Where's
a
the
reasoned
finding?
order.
Where is that? 11/7/2016.
That's there. That is at page 454.
What is the reason given?
Like I was saying, it's nothing really. They only say that there is a pending list. That is all.
Understandable.
So, Malaj, in my humble submission, there is no actual finding on the merit of it. Tilak Nagar again does not have a trademark. Nobody has a trademark. We are the only ones who have a trademark.
Yes, sir. Mr. S.N. counsel the petitioner issue notice. MSD Yangi Leonard AAG with so is present behalf of respondent 1, 2, 3. Notice to issue to respondents number 4 and 5.
4 and 5.
Within 3 days, yes.
Highly obliged.
But you see, it's very difficult. I mean, against order of board revenue, fine, but then
we'll try to satisfy Manoj on this issue.
The private respondent claims that they have been assigned the trademark by the petitioners. And so there's a serious dispute which is hotly contested before the Bombay High Court.
So you understand it's an IP case.
Item number 5.
Highly obliged.
How much time?
It's 10 days, Manoj, to obtain instructions.
10 days?
It's coming up for motion for the first time, Manoj.
Is name?
Bikasano, Your Lordship.
Bikasano. MS Bikasano. Issue notice. Ms. S.N. present accept notice on behalf of
Sole
the
respondent.
Sole respondent. No further notice called for. This is a matter of 10 days for instructions.
Highly obliged. Please write down the details of the order.
Item number 6.
Meet please, Your Lordship.
Yes.
This is the delimitation matter, my lord. And Mr. Paul has taken time to file.
On law. We'll close it. Yes, what replies do you have? Yes.
One more week accommodation may be granted, Your Lordship. One more week accommodation may be granted, Your Lordship.
For?
To file the affidavit, Your Lordship.
Weeks or 2 weeks.
So they're sending you since the junior.
Let it come after 2 weeks, my lord.
Cannon fodder. Where's Mr. Thapa? Where's Karun Lang? They're all hiding. Send the poor fellow just to face the fire.
Lordship, we are just praying for 2 days time, Lordship.
Yeah, here the issue is locus.
Lordship, let this matter come after 2 weeks.
License to drive a vehicle.
Yes? After 2 weeks?
2 weeks, Your Lordship.
Let this matter after 2 weeks, my lord. After 2 weeks. Because the election is also.
Much obliged.
On the prayer of counsel for the petitioner.
7. Item 7.
No?
May it please Your Lordship. Your Lordship, the private respondents are ready to file their affidavit, Your Lordship.
My lord, I will file on the course of the day, my lord.
Yeah, Ms. Keletep.
Yes, Keletep.
Ms. Keletep submits that the affidavit on behalf of the respondents 5 and 6 will file in the course of the day. You already filed yours? Yes. Very good, yes. Just up to 2 weeks for rejoinder. Yes.
Item number 8.
Lordship, here I pray for another 2 weeks time, Lordship. My affidavit is almost ready, Lordship. Waiting for the signature, Lordship.
So you said 2 weeks will take to sign?
Even 10 days also, no issue, Lordship. Because most probably he was sent for election duty, Lordship, that the president.
Who was the person sent election duty?
That the president of the school managing committee, Lordship. He is the school teacher, Lordship.
May it please, Your Lordship. Let it come for admission hearing, Your Lordship.
What's the matter about?
He's the assistant teacher. Required qualification.
You have MTET.
MTET, Your Lordship. He lacks that criteria, Your Lordship.
That is the ground, Lordship, taken by the state.
And also the advertisement also has been stayed, Your Lordship.
Lordship, there's an interim order.
No, not advertisement.
There's no advertisement.
Lordship, yes, there is a direction to advertise the post, but because of the order passed by this honorable court, that has been halted, Your Lordship.
Lordship, I may be allowed to file rejoinder to the state affidavit.
I'll 2 weeks, Lordship. I'll file it.
And
Yes, Mr. N.D. Shulai, or Mr. S.K. Sheikh, on behalf of the private respondent 5, please are allowed to praise for further 2 weeks' time, as the said respondent has been deputed for election duty. The prayers allowed. Stop. Next one, Mr. N.D. Shulai, AAG, submits that there's some urgency in the matter, as recruitment has been stopped, has been suspended due to the
Lordship, yes.
due to the pendency of the writ petition. This matter after 2 weeks for admission hearing,
Lordship,
and for rejoinder to the affidavit filed by the state.
And to the managing committee, if necessary.
Highly Your Lordship.
Item number 9.
You filed before that, Mr. Sheikh.
I'll file.
Apply, Your Lordship.
Lordship, I've received the affidavit, Lordship, filed by 1 and 2, Lordship. With regard to 3, 4, and 5, they have not yet entered appearance. As
So
per the
let it go ex parte against
yes,
them?
my lord. Last order.
Yes, by order dated 1/4/2024, this court had observed that though 3, 4, and 5 had been served, no appearance was made on their behalf. As such, accordingly, this matter shall proceed ex parte against the said respondents 3, 4, and 5. Who are they?
My, one is BDO, my lord, and another are the secretary, PECC. Yes, my lord. 3, Idris Mondal, the secretary, and 4, Zakir Hussain, ex-secretary, and respondent 5 is Jut Ranku T. Sangma, ex-BDO, Selsala.
Yes, sir. Ex parte. What about your rejoinder? You filed?
No, my lord, will not.
You won't file?
No.
Mr. S.K. San submits the rejoinder will be filed to the affidavit file 1 and 2. Is it for hearing or is it for
My lord,
adoption?
hearing, my lord.
It's a matter for hearing. Yes.
Much
Hello,
Item number 10.
Instructions obtained.
Lordship, we have obtained instructions, Lordship. However, we need further instructions because it's not sufficient. So we pray for some more time,
What's
Lordship.
the matter about?
This is regarding the death of the petitioner of the husband of the petitioner.
The pension?
No, the death of the husband of the petitioner, Your Lordship.
Who died in a car accident?
Car accident, Lordship.
Now, what instructions have you got? Why did you issue instructions? What is the instructions you've got? Put him on it.
Lordship, there's a prayer for compassionate appointment as well. It's one of the prayers made by the petitioner. So we are waiting further instructions on that, Lordship.
Compassionate appointment will be there. This is
Exactly, my lord.
compensation.
Lordship.
He was a serving doctor,
Lordship.
a government doctor.
Lordship. And we are still awaiting instructions from other departments, Lordship. There are 3 departments involved over here. I mean, like named over here.
Is the petitioner's wife?
Lordship.
Yes, Your Lordship.
When you apply the same MACT kind of formula to award compensation, there's just yes, MS Indishala Leonard Singh submits that the instructions received are incomplete. She prays for further 1 week's time to obtain complete instructions.
2 weeks' time, Lordship.
4 weeks' time?
2 weeks' time.
Okay, 2 weeks' time. But then did you have to consider the aspect? Because he died, he's a government doctor, he died in the course of duty, whatever. Then you have to, some kind of...
We'll place our affidavit accordingly, Lordship.
Item 11.
Much obliged, Lordship.
File?
Yes, Lordship, I have filed it, Lordship.
It's ready for hearing or you want to hear it today? What's the matter about?
This is, Lordship, the election was held. After that, the result was declared, but the respondent authorities have not approved the election, Lordship. That was the...
Why is not approved?
Lordship, there was still complaints, Lordship.
The inquiry was conducted and the inquiry officer has recommended for approval of the committee, Lordship. After that also they are not...
Well, elections are free and fair?
Yes, Lordship.
Where is the inquiry?
Lordship, the inquiry report is at page 35, Lordship. From
Who
37.
conducted the inquiry?
This Ombudsman, Lordship. The Deputy Commissioner has appointed.
Who's ombudsman?
This.
Who is appointed by whom?
This is the Deputy Commissioner, Lordship, especially for Manrega scheme, Lordship. The recommendation, the conclusion is at 38, Lordship. Page.
What did he say in the affidavit? Why didn't approving your?
Because the hetman, because they have that format. They have that format. In the format, the hetman was not put his signature, Lordship. That was the reason. That is why he is not approving. In fact, the law does not contemplate the presence of the hetman in the committee, Lordship.
Oh, last time, what do you say, Mr.
Yes,
Arun?
Lordship.
You said the
Lordship,
headman is
that-
necessary.
Lordship is necessary, Lordship.
Why?
Lordship, as per instructions, is stated that the signature of the Gambura, Lordship, being the Lordship.
Where do you find that?
Lordship.
Where do you're submitting from where do you find that?
Lordship, I've got these instructions which I've received, Lordship, and stated that thing.
What
And even as
instruction
per 7A, Lordship, it's.
The 7A is very clear, Lordship. Rule 7A, Lordship. I have quoted the rule in my rejoinder, Lordship.
He has to sign a social agreement, you mean?
Lordship.
Where in your petition you said?
In my rejoinder, Lordship, in the rejoinder, I have quoted the formation of council, Lordship.
May please, Lordship. Lordship, may I have it for listed for hearing, Lordship? We can finish.
No, we'll finish it now. Why?
Lordship,
What is
with a page. Lordship. Lordship, as
Yes,
per.
some time. Where's that? Where's the 7A?
Page 5, Lordship.
Advisor shall be recorded by every village members feature every mail.
This is after the amendment, Lordship. Prior to the amendment, the hetman was the ultimate. By virtue of being the hetman, he was the president.
You prove pagination. This matter won't keep pending. This is matter tomorrow. Yes.
Lordship.
On the prayer of Mr. H. Karwanang.
I do oblige.
Item number 12.
Your Lordship, I pray for another 2 weeks' time. Lordship.
Your Lordship, this is
How many times you prayed?
fourth time.
What?
Rejoinders closed. This is matter for hearing. Yes.
Pleasure, Lordship.
Rejoinder after the final date. Rejoinders findings is closed. Rejoinders findings are matter of right. Rejoinders closed. List for matter for hearing. Yes.
14.
Lordship, we have filed the show cause this morning, Lordship.
What is the matter about?
My lord, this is with regard to a will, my lord. There's a delay in preferring this civil division, my lord.
How many days delay?
93 days, my lord.
How many?
93 days, my lord.
Where's the?
This case number 1, my lord.
1 second.
I could not contact one of the petitioner in this case, my lord, who was the main petitioner, my lord, who has been authorized by the sisters. Because she had changed her number. Because of that reason, I could not file the civil revision within time, my lord. And one of the petitioner, my lord, she is working outside the state, my lord. That's why.
How many petitions are there? 7?
7 of them, my lord.
You're coming against interrogatory order.
My lord.
Why?
My lord, we have
Fixing
challenged
for depositions.
No, my lord. What had happened is that they had filed against a will. They had filed a probate, my lord. Probate.
For probate.
Probate form. My lord, probate has been filed by the beneficiary, my lord. In spite of the fact that this in the will itself, an executor has been named, my lord.
So the law is very clear that under Section 222, my lord, that a probate can be applied only by the executor, my lord. That ground was raised by us. The learned court below has rejected our contention, my lord.
Yes, you have. What objection do you have to the condemnation?
Lordship, let this matter be listed after 3 weeks.
Why?
For hearing.
You filed the objection.
Yes, Lordship.
What objection do you have to the condemnation application?
Lordship.
You're going to argue it or someone else?
Someone else will argue.
Listed after 1 week, yes. For
3 weeks, Lordship.
No. After 1 week, yes.
Much obliged.
Objection to the condemnation application has been filed by the respondent. So this is a matter of the 1 week for hearing on the condemnation application.
15.
It's that job card matter, Lordship. Lordship, our case is that since the BDO letters were not received by the...
Where's the headman? Tell him to come here.
Lordship, in fact, we had submitted a letter to them, asking them to submit their documents.
What documents they have submitted since when?
No, Lordship. Lordship, as per the... Lordship, may kindly see the contempt petition, Lordship. Lordship, may kindly come to page 25.
We're not going to take the excuse, Mr. Pure, that's hiding a cover BDO. PD rompak senang. Kalau rompak senang untuk mana? Sausnam. Pitip kamar rompak senang. Berdengkong lagi, berpin pej nama tak jim hajing biat nama para sausnam dah sampai. Dia mentah ni pilihan si orang berkelam tip yang cerita BDO mut film ke kameram jom film pej tu. Menpej ke jing bahang jom berkhon. Dia. Why you have not gone also, Mr. Changriso? The people.
No, they didn't come, my lord.
Why?
Just my lord. Recently, they have received the letter. Other lordship summoned for personal appearance. He had issued this letter to the parties. The parties on the same day, my lord, responded to him with the applications and supporting the comments. They went to his house. He refused to accept again. So this petitioner, they went to police to help them to deliver the paper. Police said, no, I have no role to play. So they were advised to go to PTO. They went to PTO again.
This is too much.
Really, very sad to see the conduct of the condemned.
That we had written to them, Lordship. We had instructed them to come.
I'm not look at it.
Lordship, they...
When did you give documents? Since when?
On the same date, my lord. The same date of the letter. In the afternoon, they went to his house with the supporting documents. I also advised them.
Your passport, everything you sent, Aadhaar card, everything.
They have done
There's
everything.
No
He refused again.
What is the intention, Mr. Umpir? You go to jail. Yes.
Lordship, I kindly submit. There's no intention on part of the VC, Lordship, to deprive the benefits. We only wanted the documents, Lordship. They
The
can come
documents are given to you. Believe him pediang ki court jungki. Believe him pediang court jungki. La court la berkila aku kilawan tim tere. When did he refuse? He refused it.
My lord, on the same day of the letter they received from him. They went to police.
Lordship, they can
Police
come again
advised them to
tomorrow.
video.
They can come again tomorrow.
Not
They
come
can
tomorrow.
submit it today, Lordship. They can submit it today, Lordship.
He in the face orders of this court. You're trying to run technicalities that BDO was instructed. This was done. That was done.
No, Lordship. Lordship, in
Kamu
fact...
sedang kamu ni. Pihak sanat mana? Pihak sanat no CMU. Senang sepung no CMU.
Habakimuan sarangan la kumno.
Kilawan kan usian kiong.
Kim 41.
Beli tadi sini ay biang. You submitted the passport, Aadhaar, everything.
Yes.
Have you have an affidavit in your contempt?
My lord, those things are not there, my lord. This is subsequent
This is
development.
subsequent development, Lordship. They're supposed to
After
reply to
lordship
this letter,
summoned
Lordship.
the personal appearance of the contender. Yes.
He has to appear next date.
Yes.
The tengum no?
Tay
borlin nang lang di contempt number 1 si tebron nong lang. Pirim fiu long basjong yung ka umwali. Victor Bar, West Khasi Hills is present in court personally and has submitted that the petitioners have not approached him with the required documents Stop. To this, the Learned Senior Counsel, Mr. HRI, submits that the petitions have gone on.
But on the same day, the letter is written to the parties, my lord. They deliver the letter by the headman in the morning.
No,
in
when?
the afternoon
On what
itself.
day?
My lord, I don't have the copy of the letter. But on the same day.
That the petitions had gone, but the same were refused to be accepted by the said respondent. Stop. He's directed to put him an affidavit. This is a matter after 1 week.
Yes.
Yes. The respondent number 1 to appear again on the next date. Yes. Kan biang pinlay ako ni te. Wali ka ba kaan? Mana kata?
16.
I leverage.
And it's long period, instruct your clients properly. Don't try to just defend them. Like if there's order of the court, there's a direct order of the court. It is your duty also as an officer of the court to see that it's implemented.
We have the highest
Not the highest regard. Otherwise, you also will be in contempt. If you try to put up the same defense that the BDO is instructed.
No, Lordship. By that letter, we have entrusted them to come.
May it please your Lordship. My Lord, in this matter, today only they have filed the affidavit. I am yet to go through. If your Lordship kindly grants me some time, it may be posted for final disposal on a particular date. In between, we will file a rejoinder if necessary.
Yes, when do you want?
Maybe on 2nd May, subject to your Lordship's convenience.
Yes, Mr. Datta, the resident counsel, submits that as he's just been in receipt of the county affidavit filed today, he prays that the matter be fixed for final disposal on 2nd May and to enable him to file a rejoinder to the same. Not objected to.
May I request for 3rd May, my lord? 3rd May, 1 day.
3rd May, not Friday.
3rd May.
Second May.
Yes, 2nd.
17.
Yes. Are we allowed her to resume her duties?
Yes, Your Lordship, they have allowed.
They have allowed?
Yes, Lordship.
Have you filed affidavit?
I seek for 2 weeks' time, Your Lordship.
Yes, MS and Kharchamlang submits that person orders dated 1/4/2024. The petitioner since been allowed to resume her duties. Stop. You pray for how much time?
2 weeks' time, Your Lordship.
You are appearing for?
I'm appearing for respondent 4, my lord. I'm submitting my power today.
4.
I'm appearing for Secretary, Lordship. Secretary of SMC.
1 second. You're appearing today only. Ms. Nobri, last time you appeared.
Yes, sir.
Yes. Appearance has been made today on behalf of respondent number 4 by Mr. H.R. Nath. Stop. Mr. Inongbri for number 5 and your name, sorry. Arkhashing for 6 are present. And pray for 2 weeks time to file affidavit. So,
Interim order may be continued, Lordship.
Interim order shall continue to next date.
Doubly obliged, Lordship.
18.
Please, Lordship. Lordship, I pray for some more time to file my affidavit.
My Lord, in this case, my Lord,
They died on 31st.
My Lord, I am squarely covered by that Moxadul judgment, my Lord.
Which Moxadul judgment?
My Lord, this Moxadul, Mandal. That was just deliberated by this honorable court.
You know this precious working where?
My Lord, she retired on 31st of April.
No, with the working
supply,
sorry?
Supply, my Lord.
She's covered by the old pension scheme, you say. You file affidavit. Mr. R. Gurung has submitted that this case will be covered by. Anyway, you file it. Mr. H.R. Please was about 2 weeks' time to file affidavit.
There is an interim order, my Lord.
Interim order for?
For not to recover the excess.
Interim order pass earlier shall continue next day. Why do you already put you in the old pension scheme?
My Lord.
They're recovering it now.
Yes, my Lord.
Hearing?
Deeply obliged.
Hearing item 22.
This is a
No
Cantonment
time,
matter.
Mr. Kurishi.
Yeah.
Ready today.
In fact,
Otherwise, this case become a black mark in my roster.
Because
So now we have this entire system of CIS and control and everything. So
Yes.
it keeps on flagging, more than this is going to be
2016,
matters.
it's
quite old.
Quite an old case. Only in this case, because the case was adjourned on many occasions on the ground that the building bylaws will be approved by
That
the
is
Ministry
what,
of
yeah.
Defence. And thereafter also there was a notification issued by the government that it is going to civilian area. So that also was, because of the reason also the case was adjourned on many occasions. But recently I got one more notifications, December, is saying that government, it is under process. It is under the process.
Of doing what?
Of is to transfer the entire
correct, Mr.
cantonment
Manta?
to, in the December only is what is issued. Same.
But then, according to the senior counsel last time, that
Yes,
it
because
won't affect this site, maybe other cantonments. correct?
because he was not aware. Then I have given him copy of but December. name of Shillong
is
there.
not that.
Is there? Shillong cantonment is there. Yes, number 2. Second page.
No, you haven't given me.
Second page. Shillong Meghalaya. Accession है क्या?
No.
Accession है. Yeah, in this case, Your Lordship, I pray that since the matter is pending since 2016, so in view of the changed circumstances and subsequent events, I have some alternative remedy I can seek from somewhere else. If on that ground, if I am allowed to withdraw with the liberty to approach seek the alternative remedy.
After waiting so long, in fact, this is a concurrent finding of both the courts.
Concurrent.
Under the Cantonments Act, you'll approach whom?
I have a Lordship, somewhere I have a good case.
Yes.
Only one point Supreme Court judgment is saying, because here the construction which I made unauthorized admitted. Only section 185 of the Cantonment Act says that we can file a application for compositions.
Yes, sir, yes.
But that was the one of the issue framed by the Learned Trial Court, issue number 12. The Learned Trial Court found that though they have taken a plea in the written statement that the board has passed a resolution and disposed of my applications, rejecting my prayer. But the court said, you have not, the Cantonment Board has not produced any resolution passed by the board. For that reason, not passed by the board. On that ground only, in view of Supreme Court.
You want to apply now to regularize your unauthorized constructions?
Yes.
The provision, under which provision is that?
185.
No, 185 means it's a minor deficiency. But they're exceeding 10,000, 13,000 square feet.
That is, but in this case, only Supreme Court 1996 admitted that yes. But in here, the Supreme Court has allowed again to file a representation under 85.
Let's see.
That is the only issue framed by the Learned Trial Court.
What about the building bylaws? Does it allow?
Not yet.
No, that is still under consideration, not yet.
Existing building bylaws?
Existing 0.5.
0.5 division?
It's remaining.
Of FAR?
Yes, FCA.
What's called F?
Flow ratio index.
Yes.
In this case, if I am allowed to file a representation once again.
You file
a representation under section 185, because the finding of the Learned Trial Court, which is.
Let's see that finding here.
Finding Learned Trial Court. Let's see, page 64 of my petitions. I'll just read only. Whether the representation dated 30th/8/2005 submitted by the plaintiff against the notice issued under page 64.
Mohammed Tayyab.
Whether the representation, page 64. Issue number 19. Issue number 12, para 90. Paragraph number 90. Which one? Page 64.
Issue number?
12.
12. Issue number 12 is
Whether the representation,
representation dated 30/25.
submitted by the plaintiff against the notice issued under section 85 of subsection 1 of the Cantonment Act was disposed of or any reason assigned thereof. The defendant contended that in response to the plaintiff application dated 30th 8/2005, wherein he had applied for regularization of the unauthorized constructions, the same was placed before the board, who, vide resolution number 5 dated 25/1/2006, considered the application of the plaintiff and resolved that the authorized construction is against the existing bylaws of the board, and notice to be issued under section 256 of the Cantonment Act for demolition of the unauthorized construction. Hence, in the absence of resolutions, this court is unable to accept the evidence of the defendant, and the representation of the plaintiff has been disposed of by the defendants. This is issue again in my favor, though they contended in the written statement, but they have not produced the resolution of the board before the court to decide this issue.
Now you come back to the to your page 63 of your application or your appeal, memo of appeal. Last line, with regard to first prayer, the plaintiff has failed to establish that he's applied for sanction for construction of RC building sought to demolish, but defendants in notice under 185 Control Act 24 discussed additional, and hence there's no illegality committed by defendants, and the plaintiffs having not filed any appeal against the notice of 185, the Act is bound by the notice.
There is two remedies, Lordship. Suppose if I file an appeal, the appeal, if I file appeal, then I will challenge the notice only. The illegality.
Exactly. Because under 185 now,
yes.
now regarding unauthorized construction, now you have to file a 180 is a notice to under 185.
I have not the two alternative remedies available. Two remedies are there. Either I can file appeal challenging the order of the state of the Cantonment Board, issuing notice under section 185. Suppose if in case if I don't file at all, then even I can file under section 185 for regularization, admitting that yes, my building constructed is without permissions, and this building may be regularized. In that case, the court may direct. They are duty bound to dispose of my representations. This is the judgment of Supreme Court also is said, but in Supreme Court judgment is little bit different, where the board they have taken the dispose of the application of the persons, unauthorized persons, unauthorized person who has contracted building unauthorizedly.
It's under 2006 Act.
It is under section 2024. 1924. Yeah.
Whole Act.
They may not have. The 85 says, a board may at any time by notice in writing direct the owner, lessee or occupier or any land in the cantonment to stop the erection or re-erections of a buildings in any case in which the board considers such erections or re-erection is an offence under section 184. May in any such case, in any other case, in the board consider that the erection or re-erection of a building is an offence under section 84 within 12 months of the completion of such erection re-erections, in like manner direct the alteration or demolition or it thinks necessary the building or any part thereof so erected or re-erected, provided the board may, instead of requiring alteration or demolition of any such building or part thereof, or except by way of compositions, such sum as it think reasonable.
So instead of going for
appeal,
you came sit by way of suit. To restrain them from demolishing your unauthorized constructions. And the suit was decreed against you.
Decreed against me, but many of the issues.
Second appeal also same thing. They said that the concurrent findings are there. That means I have gone through the appeal.
But this is the one of the important issues.
Now do you think that now after concurrent findings of two courts coming here now, withdrawing at this stage, whether it's permissible for you to seek other remedy when they nearly exhausted all the remedy?
No, in this case, Your Lordship, what happened?
Because the Supreme Court decision, what does it say?
Supreme Court decision, Lordship, it says, here also admitted, but here the Supreme Court has given an opportunity to file a representations.
After it's an appeal.
वो जजमेंट आ गया वन कॉपी बस दिया ना
See, this is against order under 226.
226. But only the one issues, it says the board regarding the compositions. It is seen the Cantonment board is an elected body represented by the people.
Yes.
Last paragraph. When opportunity was given, putting in on notice illegal construction made by the respondent, a reply there was given. The board had considered representation, was not inclined to exceed the request made by the respondent. Accordingly, the resolution passed by the board cannot be faulted with for as violative of the principle of natural justice. But my case is a little different. In my case, is not considered. Court has come to the conclusion that they have brought any things on record to show that the board has considered my representations.
No, it's just that the judgment of the civil court has said that you do not avail of that remedy. You have not filed any appeal under 185, correct?
No, appeal against the lies. Appeal lies.
Appeal lies. You didn't file.
So here
you came straight by a civil suit.
Yes.
To stop them from demolishing your unauthorized constructions. That's it. Correct.
But that issue is no longer a. But because we are not pressing on that appeal, filing an appeal.
Pressing on the appeal. So then it's up to you. You want to withdraw the appeals and seek other remedy. What do you say, Mr. Manta?
At this stage, that is the only drawback.
When was the illegal construction done? 2015?
2005.
2005?
2005, Your Lordship. And
when
they enjoying their stay.
The suit was filed when?
2005. Lordship, in the meantime, what happened?
Notices was served to you on what date?
Notice was served.
Initial notice for unauthorized construction.
Initial notice. I'll just find out. Initial notice was issued.
2005 year.
2005.
25/7/2005.
25/7/2005. No notice.
Notice was issued.
And then your suit was filed on?
The suit was filed in 2006.
2006.
2006.
Okay. Decreed on, dismissed on?
The suit is decided.
2015?
Yes, 2015.
2015.
Yes. And appeal preferred thereafter?
2015 itself.
Of course. And the impugn judgment is?
So now this Honourable Court, Lordship, after hearing the parties, while admitting the appeal, because this is second appeal admitted. This is already admitted. The court framed the issues.
Where the issues framed?
The court framed the issues in.
They did?
There are only two issues of frame.
When?
It was issues the frame. It is 6/4/2016. 6/4/2016.
6/4, okay.
6/4/2016. This is only two issues framed, which is the Honourable Court has found there is a substantial question of law. The first issue was framed whether learned subordinate court have erred in holding that the plaintiff appellant is not entitled to seek composition
Then they will
in
pass
respect of the
order.
building in question under section 185 of the Cantonment Act. Whether the London Appellate Court has erred in holding that the suit filed by the plaintiff was not maintainable.
See, where the Supreme Court had earned holding the plaintiff not entitled to seek composition in respect to building in question under 185. Now the court held that you never file appeal under 185, correct?
This
so
is
how can you seek composition by way of a title suit?
But this is two separate issues.
And second one, well, then appellate court has earned holding that the suit filed was not maintained for having not exhausted remedy by section 274.
Because I cannot seek two remedies at the same time. Suppose if I file an appeal, I don't have to file an application for representation to the board for compounding the offence. But if I don't file appeal, then only I can go to the board and say, yes, I have done the...
Now you mean to say that since you're pursuing a remedy in another forum, that period should be excused and we allowed your appeal to be maintained before the board?
This is why we will not file appeal. Suppose if I file appeal, there's no question of filing any application to the board. Because the order of the board will be under challenge and the court will examine the order of the board. Yes. But here we have...
You take it back. Thank you. Then it might be maintainable, Mr. Spanta, because period specified shall be computed as per Limitation Act.
It is there.
And so then they will take the excuse of
this.
It's not that this is barred or there's a special statute prescribing limitation, like election, like Resumption Act or something. Then they can take that recourse. But even then, now, can we say that them approaching the civil court is the suit not maintained because there's no jurisdictional error?
But here the issue is no more here. There's whether the learned appellate court has erred in holding that the suit filed by the plaintiff was not maintainable for his having not exhausted the remedy provided under Section 274 of the Cantonment Act. But so far this issue is concerned, the suit is maintainable under the Cantonment Act itself, which provides for filing a suit.
No, it's not in all instances. Suits not barred if there's jurisdictional error on the part of the Cantonment Board and executive orders pass. If there's some errors apparent, maybe a jurisdictional error, then maybe it's maintainable. How do you see suit? Where does it say? Show the provision.
239.
And you issue notice before you file a suit.
Yes, we have issued notice.
Like
we have asked for the exemptions.
Yes. See, it does not bar a suit.
Suit doesn't bar.
If there's jurisdictional error or some error which is apparent, on the part of executive authority.
Cantonment 273.
Where is that?
273.
No, this is like Section 80 notice. It's not. It's not a license for you to file a suit. You can file a suit in either.
No suit shall be instituted against any board or against any member of the board, against any officer or servant. This is a Section 80 notice. This is Section 2.
If I intend to file it, maintainable or not, that is the question here. Now the thing is that the question frames that you had alternative remedy to 274 to file an appeal, correct? against the executive action. Now he didn't do that.
That I have not filed.
Yes.
But I filed a suit saying that we have asked for the compositions under Section 185. That was not considered. And
but you never filed any appeal. That is under
appeal
274.
never filed.
Under 274.
We have not filed appeal. We have not filed appeal. We have not filed appeal. So, but this is the issue to be issue here. The court has framed that because why appeal is, suppose if appeal is filed, then there no suit lies. Any order passed by the appellate authority attains the finality.
So why do you say this second issue is it's not relevant anymore? Why?
Lordship, the appellant has erred in holding that.
Whether the learned appellate court had erred in holding that the suit is not maintainable in view of not exhausting your remedy under Section 274 of the Cantonment Act 1924. Correct.
But this is not the concurrent finding, Lordship. This is the trial court found. The trial court found the suit is maintainable. It is the appellate court.
So that's fine. That doesn't.
It is appellate court
the
who
thing is that again it comes to suppose wrong interpretation of law by the trial court also that that
trial
can be a
court found
substantive question of law.
Trial
the thing
court
is that doesn't mean that we are now at second appeal sitting only to do the substantial questions of law. We're not going to look at the facts, anything else. Only if it's a bundle, if like the facts intertwine to the question of law. But the thing is that now it is a question of
only
law.
for the limited purpose, the facts is required. But these two issues are involved now.
The trial court held that you're not entitled to any. You're not entitled to seek composition.
No, trial court has said, but trial court
under
said
185.
Trial court did not say this.
What did the trial court say?
Trial court has said in this case that the Cantonment has not produced any resolution of the board to show that they have entertained the petition or representation of the appellant herein.
Okay, you take the court to that relevant part and we will dictate the judgment here.
65. No? 64.
Where is it?
64, page 64.
64 is appellate order.
Oh, appellate court has not decided anything on this.
64 is the trial court order?
Trial court order.
Okay.
64, whether the representation dated 30th/8/2005 submitted by the plaintiff against the notice under Section 185, subsection 1 of the Cantonment Act was disposed of or any reason assigned thereof. The defendant, 64, Lordship. The defendant contended in response to the plaintiff application dated 30th/8/2005, wherein he had applied for the regularization of his constructions, the same was placed before the board, who vide resolution number 5 dated 25/1/2006 consider the application of plaintiff and resolve the unauthorized construction is against the existing building bylaws of
There's
the
nothing.
board.
Where are you reading from?
64, issue number 12. Page 64.
I think you're reading
Running page
54.
60.
Issue number 12 is
Para 19, issue number 12.
1 second. It's page 57 here in the court copy.
Right?
All pagination.
Muhammad Tayyab, Lordship.
Muhammad Tayyab, yes.
Sorry. How the copy is not?
You're reading some other memo of appeal. 57.
No, is it Tayyab only? Sir, okay.
64 is red in red pen.
Yes, red pen, Lordship. Red pen 64.
Red pen is your code, no? Okay, yes. There are two page numbers here.
Oh, yes. Red pen, Lordship.
Okay. 64, right, okay.
Yes, this is the issue number 12.
Yes.
Whether the representation dated 30th/8/2005 submitted by the plaintiff against the notice under Section 185 of subsection 1 of the Cantonment Act was disposed of or any reason assigned thereof. The defendant contended in response to the plaintiff application dated 30th/8/2005, wherein he had applied for the regularization of the unauthorized construction, the same was placed before the board, who vide resolution number 5 dated 25/1/2006 consider the application of the plaintiff and resolve that the unauthorized construction is against the existing building bylaws of the board notice under Section 256 of the Cantonment Act for demolition of the unauthorized construction. This has been reiterated by defendant 1. However, in the absence of resolution, this court is unable to accept The evidence of the defendant and the representation of the plaintiff has been disposed of by the defendant. The issue is decided in negative. So this issue is decided in my favor, though they say that yes, representation is received and disposed of by the board by resolution so and so, but that was not produced before the court.
The next point.
What is it? And second point, that was not the issue before the trial court. Whether the learned trial court has erred in holding that the suit filed by the plaintiff appellant was not maintainable for having not exhausted the remedy. That was not the issue framed by the learned trial court at any point of time.
What was the issue? 1 second. Yes. Where's the finding of the trial court on that point?
The trial court has not given finding on this.
There's no finding at all.
There's no finding on this.
So you mean the issue was wrongly framed?
Yes. There's no finding.
Where is the suit on maintainable in the judgment?
Your Lordship here.
You kindly help, Mr. Manta. Where does the trial court say that the suit
Your
is
Lordship,
maintainable?
in fact, since under 185, when the resolution was there, the resolution was not produced because something happened with the records. So due to that, it was held against us. However, they could have gone on appeal on that 1274.
Yes.
Since they didn't go appeal, but that was not the issue. But that is a new thing he brought in.
No, I'm not.
Where it's recorded that the suit is unmaintainable anywhere in the trial court order?
Lordship, if I come to the cause of action, page 53, issue 5 framed by the court, issue number 2.
Yes.
Here the court found that there is a cause of action for the purpose of filing the suit.
Where is that?
Page 53. The brief facts of the plaintiff is that the plaintiff is one of the co-lessee of Volume 71, had applied for the sanction by giving notice in writing to the defendants on 7/11/2000, along with the building plan for renovation or reaction of the building. The defendant, white letter numbers so and so, directed the plaintiff to deposit the sum ₹75, only being the building application process fee, and accordingly the plaintiff deposited the same white receipt number so and so. However, the Cantonment board neither refused nor accorded permission. Instead, returned the building plan white letter dated 14/3/2003 on the ground that the processing fee was not paid. The plaintiff once again deposited the processing fee of 75 white receipt number so and so with the request to accord sanction at the earliest. The defendant returned the building plan unsanctioned white letter dated 24/4/2003 on the ground that the proposed building plan did not conform to the building bylaws, Ceylon Cantonment. The plaintiff resubmitted the building plan and the same is pending sanction 2003. The plaintiff contended the failure of the defendant to grant sanction in spite of repeated efforts ought to be taken as a granted by the plaintiff. The plaintiff contended that the defendant, without proper application of mine, issued notice under section 185 of Cantonment Act. The plaintiff filed a representation before the defendant dated 30/8/2005 refuting the allegation. The plaintiff contended that the defendant, without disposing the representation dated 30/8/2005 submitted by the plaintiff assigning valid reasons, issued notice under section 256. Wherein the plaintiff was given 15 days time for demolition of the alleged unauthorized construction. The plaintiff contends that he has not violated any provision of Cantonment Act or any rule of law in force. The case of plaintiff is outside the purview of the public premises unauthorized occupants Act. The expression cause of action has been defined as a fact or facts which establish give rise to a right of actions or existence of such entitled to party to seek redressal in the court from the facts of stated the plaintiff above. The non-disposal of plaintiff representation constitute a cause of action. The issue is thus decided in affirmative. Then second issue is whether this court has jurisdiction to entertain and try the suit.
That's not important.
This is important.
Yes, Mr. Manta. There's no finding, I think, on maintainability.
No.
He's right. Yes.
So in fact, that appeal, he didn't avail it.
Yes, appeal and avail.
He
Yes.
didn't avail. He straight went to the suit. So that being the admitted position now, and it is also admitted that illegal construction having been done. And I have given
his
the
case is that he had applied for sanction, but that was
Yes.
not processed nor refused.
But
And
without
after the notice was given to them, then they wrote for composition of authorization. But the Cantonment board did not.
Agree.
Case resolution was not produced before the trial court. So on that not being produced, no finding could be rendered by the trial court.
Yes,
But
yes.
regard whether the resolution was good or bad. That's it.
because the construction, it is a violation of 6,496 square feet approximately. Means the total
6,000?
construction. 6,000. It's a huge area. That cannot be compounded. There is a reason.
And what does the appellate court say?
Appellate court upheld all this.
Appellate court has given very different finding, which I couldn't understand. So appellate court findings. Appellate court in page 80, para 30, regarding this, because this was brought for the first time before the appellate court by the board. The appellant has contended that under section 185, there are two remedies. The remedies sought by the appellant is for the composition, and appellant did not prefer other remedy, which is to challenge notice under section 85 by way of appeal under section 274. The London Trial Court has considered the issue number 1314. No issue has been framed and no evidence led for prosecution under section 185, but appellant has been held to have violated. There is no issue have framed on this.
There's a finding of the
appellate.
This is your ground of appeal, correct?
Ground of appeal.
This is one of your grounds of appeal.
My ground of
What is
appeal.
the finding of the appellate court? Now see see at 81B. 81, page 81, paragraph 34B.
81B. 81B.
Yes.
Whether the civil code is maintainable without exhausting the remedy which provides an appeal.
Yes.
Whether building by this is the one of the issue. It is by the
That
appellate
from
by
here
the
the
appellate
issue
court.
has come.
By the appellate court, not by the trial court.
The law point, yes.
But,
no, understandable. That is why this point has come for the first time with regard to not availing remedy and to
First time it came. The findings are not here.
Where are the findings on that point?
I didn't find finding.
He has to render a finding. He's framed a question.
Regarding 184, because 184 is the offence.
No,
They
correct.
have to
No, correct. Regarding to this 34B.
34B 85. Just quoted.
There must be a finding somewhere.
Let us, I think, next page, page 82, paragraph 36.
There is no finding. No finding.
They have discussed 274.
Yes, 36.
274 is regarding the notice. That is altogether different.
No. 273 is notice. 274 is an appeal.
274 appeal. So here the appellate court has examined on perusal of the record in respect of the point whether the suit is maintainable for want of notice under section 23. The court finds the waiving of notice has already been allowed.
Yes, this is a finding on. This is, he said, not maintainable. Right. Is that trial court?
It says the suit of the plaintiff is maintainable without issuance of notice.
That's why, as such, on this count, the apparent plaintiff's suit is not maintainable as he has not exhausted remedy.
But on the point whether suit is maintainable without exhausting the remedy of section 74,
Now the
such
findings,
provides for
findings in
appeal.
para 36. How can we say there's no finding?
This is a 36.
Read last part of 36, which
The
is
finds
page
that
83.
the schedule 5
No.
in serial 10, appellant could have
Forget
preferred.
that. You read next page. Last part of it is seen, see, 3 lines on the bottom from 83
Yes,
to
yes.
82. Just
He has given the
you
finding.
seen the appellant did not exhaust. You said there's no finding on this.
The appellant suit is not maintainable as he has not exhausted the remedy provided in the Contempt
How
Act.
come you said there's no finding on
No,
this?
this is the finding, but this was not the finding before the trial court.
That is maybe wrong typographical. That it should have appellate
Before
court
the
should be-
civil court. So this is the one of the issue, because I am not pursuing. I have already submitted before the trial court also. There are two alternative, two remedies are available. Suppose if I choose the remedy under section 185
Okay,
of the
issue
Cantonment.
number 2 we know. Now issue number 1, whether learned subordinate courts have erred in holding that appellant is on entitled C composition. Are you entitled C composition or not? What was the finding? The finding said that there's no resolution, nothing is there, so under what provision of law are you entitled to seek composition? Or for realization of the unauthorized construction?
Construction, yes.
Under what provision?
Under 185. 185? 185 is the provisions. If I may read one second.
Are you entitled or not?
You see, suppose if I file any remonstrations, I'm entitled because if they, because the prosecution under section 184 of Cantonment Act is also there. Suppose if I file, if I made illegal constructions, they can file a criminal case against the persons before the court of chief judicial magistrate to prosecute the persons. And there also the law says it can be compounded. 185, 184 Lordship. Illegal erection or erection. Whoever begins, continues, complete.
1 second.
184.
No, 185 is only the notice.
Section 185 and 184. 184 and 85 is interlinked because the prosecutor, the Cantonment Board has not brought anything on record to show that I have committed an offence under section 184. The entire evidence they have not produced any records. There's no finding on this also.
Mr. Mantha, anything to say?
Your Lordship, it is all the issues, they goes with the violation of the construction. So it is admitted and both the trial courts have held that yes, there is a violation. And the evidence also, plaintiff also admitted in the cross. It can be gone through, Your Lordship, it will take time.
It's issue of law only.
So now question of these laws already they haven't gone through.
We will not go into the factual aspect any longer. We just stick to the law. Yes.
So in my responsible submission that he cannot avail now that remedy which he had abandoned by himself after so many years. That's my responsible submission. And there is no merit in this.
So demolition.
Still, the Cantonment Board very recently, in some cases, already said till the building bylaws is passed, approved by the Ministry of Defence, not to go for demolition.
That will be after the order of this court. There is no illegality at all in the concurrent findings. And even the finding, the additional issue was framed by the lower appellate court with regard to non-availing of remedy 274 will make a suit unmaintainable. But that helps him in a way. Because we cannot stop him from filing the appeal. That's for the board to consider.
My respectful submission, after both the courts having done,
all the matters are similar, no?
Similar, only Lordship, this Tanvir matter is a different issue because here the legal heirs issue is there. The issue is little bit different here. These are the note the issue here before the RSA 4. Tanvir Ahmed.
Was separate orders passed or same order was passed?
No, separate order passed.
In all the cases?
All the cases.
But similar issues?
Similar issues.
Similar findings.
Except this case, RSA 2006. Because here these are the issues not decided. Because the person, the lessee died and the legal heirs was not substituted. The court framed 3 issues in RSA 4. The issue is whether the learned subordinate court have erred in holding the suit filed by the plaintiff appellant as heirs of the deceased co-lessee. 4.
Tanvir Ahmed.
Tanvir Lordship.
Yes.
Whether the learned subordinate court have erred in holding that the suit filed by the appellant's plaintiff as heirs of the deceased co-lessee, selling the notice issued in relation to the construction raised by the deceased is not maintainable. Whether the learned subordinate court have made a misplaced reference of section 146 of the Code of Civil Procedure to hold that the suit filed by the present appellant's heirs of the deceased is not maintainable. Whether the facts and circumstances of the present case, the notice as issued by the respondent was against a dead person's, hence unsustainable in law. This is altogether different issue.
It is separately. Yes.
Yes, it's a separate issue. And rest of the cases, almost the issues are same.
Yes. Take down. This bunch of second appeals, namely the number, apart from number 4, the rest. Being directed against concurrent orders of the subordinate courts, orders of the lower appellate court. Whereby the order of the trial court was upheld before this court stopped. This court by order dated on admission of the appeals by order dated 6/4/2016 had framed the following 2 issues. This one you take from here, yeah. Whether let someone goes also holding, whether appellate court and so on. Stop. The brief facts are that the appellant had applied for permission for reconstruction. So you applied or you didn't apply?
We applied.
They applied. And the same were rejected as they were not in conformity with the bylaws.
Bylaws.
With the bylaws. And it appears the appellants made unauthorized constructions and thereafter had filed for regularization of the same, which was rejected by the Cantonment Board and which resulted in notices under section will be under 250
185 first.
Under section 185
Of the
and section
Cantonment Act.
256
Thereafter.
Stop. The appellants against the said executive orders then file respective title suits in February 2006, which came to be dismissed by judgment order dated 5/5/2015 by the Court of the Assistant District Judge. Stop. Thereafter, the appellants preferred a first appeal before the District Judge East Kasil Shillong, which also came to be dismissed by judgment order dated 6/11/2015. Correct?
Yes.
Mr. M. Kurishi, in his submissions, what were his submissions? Submits that with regard to issue number 1, as to the issues framed by this court, in issue number 1, has drawn attention of the court to to page 64, right? To 64. 1 second. No, it's okay. To issue number 12, framed by the trial court, which is as follows. I would with the inverted commas, quote, whether the representation dated 38,005, submitted by the plaintiff against notice issued under section 185 of subsection 1 of the Cantonment Act was disposed of or any reason assigned thereof. Stop. It is submitted by learned counsel that while returning a finding on this issue, there was no certainty inasmuch as the resolution referred to was never produced. The resolution rejecting the permission by the defendants therein was never produced before the trial court, and as such, the evidence not accepted. This, he submits, has been left open-ended. Correct? Has been left open-ended, though the issue was decided in the negative. Stop. As such, he submits that.
But Lordship, that issue 12, that has been decided in issue number 13, Your Lordship.
Yes.
The 12.
Well, 13 is only whether they can issue notice. What do they say?
There is regarding 56, this 256.
So, no, 56 just says so. No, non-compliance 185. That means that you're competent to take action 256. That is
Yes.
all. Yes. There's no ban on issue notice of sale. That will not enter because it's not common issues. Next para. On the second issue framed by this court, the learned counsel has submitted that it is not the trial court that had held that the suit filed by the plaintiff was not maintainable for not having exhausted the remedy provided under Section 274 of the Cantonment Act 1924, but rather was a question of law that had been framed by the lower appellate court, which had rendered a finding therein that the suit was not maintainable. Stop. At this juncture, he submits that the first issue having not been answered conclusively and his suit having been found not to be maintainable in view of not availing the remedy as far as Section 274, the appellants, this court, sorry. As the issue has not been answered. At this juncture, he submits that the first issue concludes conclusively by the trial court, and also the second issue having been found that the appellant has not exhausted the remedy provided under Section 274 of Cantonment Act 1924, the appellants may be allowed to pursue statutory remedy as provided by statute, notwithstanding the dismissal of the suit and the findings of the lower appellate court. Next paragraph. Mr. S.P. Mahanta, learned counsel for the respondents, has submitted that the prayer made at this late stage by the appellants is unsustainable for the reason that the entire process has been gone into and evidence has been tendered in the suit, which has clearly established the unauthorized construction made by the appellants, and therefore by the operation of the statute itself, the said unauthorized constructions are liable to be demolished. Stop. He therefore submits that there being no illegality in the findings of both the trial and the appellate court, the second appeals are liable to be dismissed. Stop. Do you want to see any other thing that question realization will? You want to see anything about the bylaws? Not necessary.
No, Your Lordship. In fact, all the issues were discussed at Trademark. Trial court has discussed.
It's already gone through. And the thing is that regarding, you see, to show that it's not a making a case for you, it's just that Now, if evidence has been gone into and the construction unauthorized and which are not permissible by the bylaws, that means the appeal be futile.
Futile, it will be futile exercise. Because why? Your
before
Lordship,
dismissing,
like,
he further submits that
like, if Your Lordship, I have filed this, the detail of the unauthorized construction.
yes, I've seen that. I've seen that somewhere here. And anyway,
those things I have given.
We're not going to go to facts.
Facts.
We're just addressing the
Only the
subject
law
question
point.
of law
Yes.
which has been framed by this court. Before that, as dismissed, he further submits that as the unauthorized constructions and I forget that part, not necessary. I think yes, why should you go to bylaws? Yes, heard the counsel for the parties stop the substantial questions of law as quoted above will limit the consideration of this court only on the said two issues. Stop. With regard to the issue, substantial issue number 1, whether the appellant is not entitled to seek composition in respect to building question under Section 185 of the Cantonment Act 1924. It is noted by this court that, where is that page 64, correct? It is noted by this court that the trial court has come to a clear finding that with regard to the prayer made in the plaint, the plaintiff had failed to establish that he had applied for sanction for construction of the plaintiff had all the same. I hope they're all the same.
All same.
Same,
What you do
yeah.
construction?
No, sorry.
It's not same.
The plaintiff's appellants had failed to establish that they had applied for sanction for construction, which are sought to be demolished by the defendants in the notice under Section 185 of the Cantonment Act 1924. And as the plaintiff has not preferred any appeal under Section 185 of the Act, was as such bound and not entitled to any relief. Stop. That this said finding on the basis of the evidence tendered cannot be faulted with, inasmuch as the appellant had sought remedy before the civil courts by abandoning statutory appeal under Section 274. Stop. On the second issue, It said appellate court. On the second issue, on the finding of the appellate court, in holding that a suit filed by the plaintiff appellant was not maintainable for not having exhausted the remedy under Section 274 of the Cantonment Act 1924. A perusal of the said section itself has provided for appeals from executive orders and the executive orders have been described in the schedule itself. Which schedule is that? Schedule itself to schedule. Sorry. In the schedule, in Schedule 5 to the Act itself, wherein the appellants could have resorted to availing the statutory appeal before the Cantonment Board within 30 days of service of notice. Stop. The finding, therefore, that a suit is not maintainable for availability of alternate relief is also correct and is upheld by this court. Stop. For the reasons stated for the aforementioned reasons, there being no error in the findings of both the concurrent findings of the courts below, the second appeal is answered accordingly and is dismissed.
Regarding the composition, still this is there.
We can see we are going to statutory appeal. You can file; it doesn't matter. I don't want to give a finding in the main appeal itself that you can see. It's not, we're not under certain jurisdiction. So we're only looking at the findings of the court, whether it's right or wrong.
No, only because the Supreme Court judgment which have relied upon, Lordship.
That's 2 to 6.
2 to 6, but even in this,
we're not saying 2 to 6. Here we are bound. You know Section 100 of the CPC, correct? We are totally bound. I'm bound to the court's bound to answer to survive the law.
But
you
this,
answer. First one is that you're entitled to composition because you never took any. You sought any relief, appeal against 185. And number two is that your suit is not maintainable. Finish.
My suit is not maintainable, Lordship.
The finding appellate court is correct.
Lordship, 185 only composition. That can be, Lordship.
We're answering the subject. Sorry, Mr. Qureshi. You can take your chance and file an appeal, but it's up to them to decide. Because Limitation Act applies in appeal 274. So if you're pursuing a remedy for the wrong forum, you can take the excuse up to them, but we're not past direction. Sorry.
Lordship, may I pray that she's assisting me? Her name may be.
Yes.
Lordship, only.
LD and thank you.
Lordship, in this case, there's one more case.
Another one, Tanvir, yes.
Tanvir and one more, Mustaqim also a little bit different.
Now you're saying Mustaqim different.
And one more issue is incorporated here, Lordship. Issue number 3 is there. Tanvir and Mustaqim also. Because here it is not mutated in the name of the issue is that whether the learned subordinate court have erred in deciding the issue number 6 on the question of right of plaintiff appellant on the basis of the registered gift deed, merely with the reference to section 73 of the Cantonment Act, and I have failed to consider the mutation is essentially for fiscal purposes. This is one of the issues there.
Mutation is that it's not a.
There is nothing. There is only for a matter of record to keep on the record.
Whether the learned subordinate court have erred in deciding.
Which one is that?
RSA number 6.
RSA number 6. We'll add a footnote.
Yes.
RFA number 6.
Did the trial court render any findings?
No, the trial court has, there is a findings there regarding the gift deed.
Where? Now, Mr. Kurishi has said this at the outset before the court took up the matter. That is cover only.
But this
now
is
cover.
This is one of the substantial questions framed.
6 and the Tanveer is 4. So it will be only. They want to cover only 1, 2,
3. 1, 2, 3.
1, 2, 3, and 7.
1, 2, 3.
RSA 1,
Ahmed is
2, 3, and 7 will be covered.
Yes.
4 and 6 is out.
4 is out.
There's no 5. Someone number 5.
No 5 is there.
So 4 and 6 will be out, no?
Out, yes.
Then what will 4 and 6?
This is the same thing, same unauthorized construction.
No, but the issue is different, Lordship.
Yes. You address the court on 4. Tanveer Ahmed, what do you say?
Lordship, the issue can be taken up some other date, Lordship. You have to prepare for this case. CPC is involved here.
This is the same thing.
No, issue is not same. I have already read before the report only.
Okay, the other two matters, number 4 and 6.
4 and 6.
RSA 4 and 6, as Mr. Kurishi seeks some accommodation to prepare the matters to prepare the matters. This is matter after 1 week. Yes, this is a great note.
Deeply obliged.
Item 33.
Who's for the headman?
Your Lordship, as per the instruction, the page E.
The pumps are functioning.
Has been commissioned and it is now fully functional after this MSCL has given this power
Very good.
connection.
Do we close it petition then?
Actually, two weeks ago, Your Lordship, she received only an insufficient amount of water.
How much? 1 bucket or 2 buckets?
She didn't say. She said it was insufficient, but that was 2 weeks ago.
What water you received?
Only 2 weeks ago.
So
But,
Mr. Sinkram prays he will have to obtain instructions. This is matter on day after tomorrow. You bring your photos that time.
Yes, sir. Hello, bless you.
Your Lordship, if I may get a copy of that.
You ask him. He's your friend, correct?
I'll give you, sir.
Yes.
36.
He has not produced the court as yet.
Good day.
Yes, where's the petitioner? None appears for the petitioner just after 3 weeks. Yes.
Very much.
I think lost interest.
37.
Yes.
Please, Lordship, this is regarding the not allowing the petitioner to join us in the chowkidar, because this petitioner was working as a master role since for the last 10 years, Lordship, and thereafter...
Not allowing to join chowkidar?
The master role. Now, thereafter, my lord, the... Lordship.
Yes, what is in the affidavit?
Yes.
Lordship.
Despite the affidavit.
Para 6 and 7, Lordship. Here what happened, Lordship? He is a casual worker, Lordship. He was appointed 2013.
She or he?
He, Lordship. He. Then in 2023, Lordship, he was appointed for a period of 89 days. In the regular appointment, Lordship. For 2023, Lordship.
Okay.
The appointment order was made in 2nd June 2023. However, his joining letter, Lordship.
2nd June 23.
23, Lordship. But he went to join in the office on 1st of June 2023, Lordship. In the office of the respondent 4.
So what's wrong with that?
Because appointment letter is joining letter is prior to the date of appointment, Lordship.
Must have been informed,
Lordship,
that he's being appointed.
Now,
there.
Lordship, the appointment was for a period of 89 days. Now that 89 days has already been expired, Lordship. In the appointment order itself mentioned that he cannot claim for further extension, Lordship.
How come he joined before appointment came out?
Lordship, because
You went for
the Annexure
error.
2 is very clearly stated that I have joined on 2nd because that joining was counted from with effect
My
from
Lord,
June 2023.
page 20
because that appointment order is very
Page
clearly
20,
stated.
Lordship.
Of his petition.
Page 20 of the writ petition, Lordship.
It is very clarified.
In
because
the interest of public service and the smooth running of the office work of so-and-so, is hereby temporarily appointed as Sakidar.
Now what happened? He joined on 1st.
No,
Where's
he-
the date? No date is there.
No, we have not
just
mentioned
said
the
on
date.
21
Yes,
years. On 1st June. He made a mistake, so pay him 89 days.
No, he it's not that he made a mistake. How can he come to the office prior to the date of his appointment, Lordship?
Then the appointment letter is there the next day.
Yes.
So that is why we have that respondent number 4 has instructed the petitioner to join before the office of the respondent number 3. But he did not come to join before the respondent number 3 who has issued the appointment, Lordship. He did not come. No. And moreover, Lordship, that he is just a casual worker.
You withdraw, there's nothing the case. 89 days gone.
Lordship, because this one is make an arrangement for temporarily because
Temporary, you have no, for temporary appointment, you're not cloaked any vested right.
No, Lordship, my only submission is that I'm not claiming for the regular force.
No, not claiming. You're just saying they didn't allow me to join. That's all. When you file the petition, maybe that 89 days still going on.
That time,
because Lordship, even now also they have not made any advertisement for regular.
Doesn't matter. Yes, heard Mr. P.T.
Lordship, I will just only one submission, Lordship.
Yes.
Only Lordship, just let the petitioner may be allowed to continue in the same post.
As casual worker.
Casual worker, as a master role. Only that.
You can't issue this order. It's up to them.
Because now they are not allowing me because they have promoted me. After that, they're saying that
They hadn't promote you. They said let you.
Yes,
There's no
yes.
chokidar. They said okay, you go and be a chokidar for 89 days.
Lordship, that is there, but after this order, they neither allow me to join as a chokidar, nor they allow me to work as a master role. That's the only thing. Only make some observation that I should be allowed to
Mr. P.T. Sangma,
continue.
The writ petitioner, sorry, before this court is with a prayer to direct the respondent to allow him to join to the post of chokidar as per appointment order dated 2/6/2023. Stop. Mr. P.T. Sangma submits that the writ petitioner was serving as a master role.
Yes.
Master role in the office of
PHC.
The chief engineer or the fourth of the subdivisional officer, PHE, Bajing Doba, subdivision or Garhil district, was temporarily appointed against the vacant post of Chokidar by order dated 2/6/2023 for a period of 89 days. However, he submits, though he had joined in the said post with effect from 1/6/2023, he was not allowed to discharge his duties.
Lordship.
And the journal report not accepted.
Lordship.
He submits that the action of the respondents as arbitrary
Lordship.
in denying him the temporary post of Chowkidar without any reasons being assigned. Mr. S.A. Sheikh, learned JA for the respondents, has submitted that the appointment order was issued by the respondent number 3. Respondent number 3 on 2nd June 2023 for a period of 89 days. But the joining report, the joining letter of the writ petitioner is dated 1st June. Which is highly improbable, as a person cannot join to duties until upon orders are issued. Stop. He further submits that the point in issue is no longer alive, inasmuch as the period of 89 days for which the petitioner would have served have long since elapsed. They have submitted that there being no no point for consideration any further in this writ petition, the same may be dismissed. Stop. What else? Anything else to say?
Lordship, I just that the petitioner may be
PD Sangma
allowed to continue.
At this stage has submitted that the writ petitioner
may be allowed to continue.
The petitioner has also not been allowed to continue as a master role.
Lordship, after the
temporary appointment
Lordship
of Chowkidar was also not allowed to him. He prays that some special consideration be given by the respondents. He prays that directions be issued for special consideration by respondents to allow him to continue in the post which he served earlier.
As a master role.
As a master role.
Lordship.
Stop. Having heard the counsel of the parties, it is apparent on the face of the record itself that the appointment order dated 2/6/2023 issued by respondent number 3, but the joining report dated 1st June is addressed to the respondent number 4. Be that as it may, as the point of contention no longer exists, as the period of 89 days has since elapsed, this petition is closed. However, with the direction that the respondents may consider to allow the petitioner to continue in the post as a master role, and further to consider him if fit,
Lordship,
to discharge duties as Chowkidar.
Lordship.
Yes.
Lordship.
With the above noted directions, petition stands disposed of. You already gave him a chance, give him another chance.
Lordship.
My lord, as per the RCW rules, lordship.
We know.
Yes, that also not qualified, lordship.
No,
now,
10 years, 10 years, my lord.
If he's eligible, yes.
That is
RCW is 10 years, less than 10 years, my lord. It is there.
Yes.
Yes,
Mr. That matter was called out. Where were you?
I was just outside.
You ready for the matter?
Yes, ma'am.
You have to take another day. All the orders passed. Why are you outside? The matter's coming up.
I made a call to my senior.
When do you want it?
No, sir.
When do you want it? Who's the other side? Who's appearing?
Mr. AG.
When?
After 2 weeks.
After elections?
After elections.
After, okay. And this is 3 weeks, like 2 weeks. So,
Much less loss.